Good, good.
Okay, we are live, and this is the matter of Rice. I never am sure how to pronounce this. Atenga versus Yanni et al. Docket number 18-272NH. And we've got a couple things set for this afternoon. The first is my ruling on the defendant's motion for partial summary disposition. And then we also have a pretrial conference. So I'm going to address the summary disposition first. And after we do that, I'm going to turn off the live stream and dismiss the court reporter so that we can do our pretrial the way we always do pretrials, which would be in chambers, and they're not on the record. So I also wanted to, just as a way of background in this case, what's happened so far is the defendant brought a motion for partial summary disposition, and the plaintiff filed a response. And at the time that we did oral argument, the defendant started responding to something that the plaintiff had raised, and the defendants hadn't filed a reply brief. They were just responding to it in oral argument. And the plaintiff had an issue with that. I had an issue with that because I like to have things briefed. So I asked for supplemental briefing, even though we completed the oral argument. Everyone had a chance to be heard, and they argued the issues that hadn't been briefed. But I then asked for supplemental briefing, and that has occurred. So the reason I give that background is, at this point, I've heard the oral argument on everything, and I've had enough briefing, and I don't think it's needed to have any additional oral argument. I've considered everything that's been put forward before, and the briefing and supplemental briefing, and I'm ready to rule on the defendant's motion for partial summary disposition. By way of further background, this is about the plaintiff's treatment that occurred in November of 2015. And what caused the supplemental briefing was this issue about section 17548 of the Health Code. At the time of the plaintiff's treatment, that provision said, quote, "A physician shall not delegate ultimate responsibility for the quality of medical care services, even if the medical care services are provided by a physician's assistant." Well, that provision was eliminated when the legislature amended the statute in 2016, with the amendment being effective on March 22nd, 2017. And what's created the issue here is that the defendant, plaintiff pointed out that the statute was amended, and the defendant has argued that the amendment should be applied retroactively. So I would summarize the defendant's argument as follows. First, that the defendant says, although there's a presumption that statutory amendments are prospective only, that presumption doesn't apply to remedial statutes that are procedural in nature and don't affect substantial rights. The second part of the defendant's argument is legislative amendments enacted soon after a controversy arises regarding the meaning of an act can logically be regarded as a statement of what the legislature meant all along, and those are applied retroactively. And then the third part of the defendant's argument is that in that regard, an unpublished Court of Appeals opinion in 2008 that was subsequently overruled by the Supreme Court, and an unpublished Court of Appeals opinion in 2012 form the basis of a controversy over section 17548, such that the amendment effective in 2017 should be applied retroactively. I have concluded that there are multiple reasons to reject the defendant's arguments. First, the specific section of the health code at issue is not procedural or remedial. It creates a substantive obligation. A physician shall not delegate ultimate responsibility for medical care services provided by a physician's assistant. The legislature simply can't create obligations that govern people's behavior and control their legal liability for that matter, and then change them retroactively to apply to past conduct. And there is certainly support in case law for that that's been cited by the plaintiff. And that's exactly what the defendant's argument would do. Even Dr. Cole herself understood her obligations at the time and acted accordingly at the time. And she's reflected that when she testified at her deposition, that she signed the chart and she did so as the supervising physician overseeing the PA and was co-signing her approval of the patient's treatment. So to say that 2 years later, Dr. Cole was retroactively absolved of that responsibility is nonsensical and not supported by the law. Section 17548 is not procedural or remedial. It placed a responsibility on physicians supervising PAs and removing that responsibility if in fact the amendment even operated to remove it, which is another argument the plaintiff has made that it did not, but that isn't necessary to be addressed at this time. But anyway, all of that cannot be done retroactively. I find the defendant's second argument to be just as untenable. The unpublished Court of Appeals opinion in 2008, and that's the Simons opinion, SYMONS, that was reversed by the Supreme Court, did not interpret Section 17548. It analyzed common law concepts of respondeat superior and agency. It ruled that agency was a factual question as it relates to a physician and a PA. It was reversed because the Supreme Court said that the physician waived the entire issue by agreeing to a jury instruction. So just as an aside, I don't really consider that to be reversed on other grounds. I call that a reversal that makes that entire common law discussion irrelevant, because ultimately the Supreme Court said that this was not necessary. The physician waived the issue. But in any event, the unpublished Court of Appeals opinion that came along later in 2012 didn't deal with any, it wasn't a conflict in interpreting the section that was discussed in Simon, or actually that was not discussed in Simons because that dealt with common law. The 2012 opinion, Crawford, stated that the plain language of the statute, now talking about Section 17548, the plain language of the statute directed that a PA is the agent of a supervising physician. So the one case, the reversed one, talking about common law respondeat superior and agency, and the later one, 2012, Crawford, talking about the plain language of the section that we're talking about here, just are not cases that deal with a controversy over the meaning of Section 17548. They not only don't represent a controversy over the meaning of it, but they happen 4 years apart and 4 years and 8 years respectively before the amendment of the statute. So that case law that the defendant cited is very specific, and this just does not fit into that case law. It cannot be considered a situation where we have an amendment enacted soon after a controversy arises regarding the meaning of an act, because none of those conditions are met here. There's just no evidence whatsoever that the legislature was responding to any controversy over the meaning of Section 17548. And there's no evidence whatsoever that the legislature intended the deletion of the language at issue to apply retroactively. And again, as the plaintiff points out, the legislature is fully able to declare an intent to apply something retroactively. And here it did not. And as a matter of fact, specifically declared the amendment to apply March 22nd, 2017. The section of the health code in effect as of the date of the plaintiff's treatment provided that Dr. Cole bore responsibility for the plaintiff's treatment, even when a physician's assistant provided it, and the defendant's motion for summary disposition cannot be granted as to Dr. Cole. The defendant's motion also was brought seeking dismissal as to the two nurses, Nurse Chamberlain and Nurse Young. And their argument is one of causation in that regard with those two nurses. And it goes this way. First, the PA testified at her deposition that she checked a monitor and knew of the plaintiff's vital signs every time she went in and checked on the plaintiff. Second, knowing of all the pertinent facts, she testified she was still satisfied that the plaintiff could be discharged. So the defendant's argument is, therefore, even if the nurses failed to communicate the information that was pertinent to the PA, there's no causal connection between their failure and the PA's decision to discharge the plaintiff. I have to reject this argument as well for the following reasons. First of all, it represents a factual dispute for the jury. That is, the jury has to assess the credibility of the PA's testimony, saying that she checked the monitor and she knew of the plaintiff's vitals and the other information and discharged the plaintiff anyway. The jury could find that that's not credible, or they could find that it is credible. But either way, if they find that it's not credible, then the causation argument that the defendants have made just completely fails. So that's a long way of saying that this causation argument is like causation arguments most often are questions of fact for the triers of fact. The other reason that I have to reject it is that the plaintiff's nursing expert testified that the nurses breached the standard of care anyway, because they should have gone up the chain of command if the patient was exhibiting the symptoms that she was, and the PA was going to discharge her. And that's a breach that's not only alleged in the plaintiff's complaint, but it's also supported by the case Martin versus Ledingham, Ledingham, which is at 282 Mich. App 158. So there's both factual disputes and also a dispute over the nurse's alleged breach of the standard of care with expert support for that. And both of those situations mandate denying the defendant's motion for partial summary disposition. So for all of those reasons, I am denying the defendant's motion. And that will conclude the on the record portion of our hearing. As I mentioned at the beginning, we also have a pretrial scheduled. And so I'll end the live stream at this point. Pretrials are not done on the record or publicly, and I will dismiss the court reporter and thank her for her services today. And we'll go ahead and do our pretrial.
Thank you.
Have a good day, everybody.
Thank you.
Thank you for your service.
Let me just terminate.